Hi there, it's Kellyanne with Grace Point Media here with Preston Ward, licensed Texas attorney. We are talking today about some of the legal questions we've been seeing from our friends and our colleagues in the events industry. Talking about vendors, venues for weddings, different events, things like that. Now, Preston, not only are you a lawyer, but you are a vendor with a fireworks company, which is probably the coolest kind of vendor I think you could be. Well, how did you start a fireworks company?
Well, we started fireworks probably about 4 years ago. I have family that owns a wedding venue, and we used to go out there to the property before it was a venue to do our family firework displays for the 4th of July. So that kind of grew into how can we do it better? How can we do it bigger? I'm always the type that, jumps all in with both feet to anything I'm doing, and we quickly learned about professional firing systems, and then it became how do we get bigger fireworks, which spawned, well, maybe we should try to market these things to get some of the money back we're spending just having fun, and it kind of grew from there.
Very cool. And you said you do how many weddings a year?
Last year we did about 100.
Okay.
So it was just about every weekend we had 2. Occasionally on some nights we did up to 4 on one night. So we've kind of been everywhere. We have a good stable of guys that help and are licensed to do all that stuff so that we can kind of expand and cover different territories.
4 in one night, my goodness. See, I thought fireworks were just kind of a New Year's Eve and 4th of July kind of thing. So clearly I just need to go to better weddings. My first question for you, though, actually about this topic, though, is there's a lot of conflicting information right now because we're navigating through restrictions set by the state, but then there's also different things that our local leaders tell us, county and city leaders. So if I have a question about my event, I'm either a vendor or a venue, who is the point person I can go to in that jurisdiction to ask about that event?
So it's going to depend on whether you're in the city or you're in the county. With the city, I think most of the code enforcement departments are the ones that are actually tasked with ensuring compliance with some of these things. I know that there's a venue in Fort Worth that's gotten a couple of complaints for not following these things and gotten contacted by code compliance. If you're in the county, different counties kind of do it different ways. I think for the most part, the emergency contact regarding COVID is going to be the fire marshal, the county fire marshal. So they're usually pretty easy to work with. And if they're not the right person, they'll definitely guide you in the right direction. So it's just going to really depend on kind of where it's at. And then even within different counties, it might be somebody different than, the fire marshal. It might be that they refer you to the county judge's office directly that makes some of these determinations as well.
Okay. I feel like that's where a lot of the confusion is lying, though, because some people maybe they don't know where to call, they don't know who to call, and then they just get stuck in this web of call this person, call that person, and
exactly. I think that the cities and the counties and everything are trying to figure this out too. It was kind of thrown on them, just like it was thrown on everybody else, where all of a sudden now they're tasked with not only doing the regular activities that they're responsible for, but also now enforcing these rules and restrictions that are just new and figuring out what they want to do with them. And you'll have cities that kind of want to be outliers, like Colleyville came out and said that they're not going to enforce mask requirements. So it might be a little bit different there than other places. And, unfortunately, it's just going to be, start with those people and then they might send you somewhere else or you might have to figure out who is responsible for those type of things in that area, and they might have designated somebody else.
So if my event is in a city that has specified different restrictions, say for instance Colleyville and the mask requirement, do I listen to the city leaders or do I still need to listen to state orders?
Well, the state orders are going to trump everything. So, when you look at the effect of orders and restrictions, it's going to start at the state, then it's going to go to the county, and then it's going to go to the city. So it's kind of like a funnel. The more you go down, the more refined they are. But if you start at the top, it applies to everything. So with specifically the mask restriction, that's an executive order that's a law that has a criminal penalty attached to it. There's some sort of fine. So Colleyville basically has said that they're not going to go after that fine and go after that money. But you still have the governor's executive order that's has the effect of a law that says everybody needs to be doing these things. Well, when you have a law like that says you have to do it, if you don't do it, you run the risk of potentially opening up yourself to a little bit of liability. because all of a sudden now you have a duty that you don't normally have, and it's making sure people wear masks, and it's pretty broad in what that means. But you could potentially be liable for negligence under a negligence per se argument. And basically, a negligence per se argument is where there's a statute that's designed to prevent some sort of harm. So in this case, there's a statute that's designed to prevent COVID transmission. So if you don't follow it and then somebody is at your place and gets COVID, I could see plaintiff's attorneys argue that, hey, you were negligent. There's a statute here. It was designed to prevent this harm, and you just blew it off, and now this person has, the sickness, or if they, unfortunately die or things like that, they definitely could try to make that argument. And unfortunately, there's not been much in the past that had those kind of arguments, just because this is such a widespread thing. It's a pandemic. The last pandemic.
There's no real precedence for it right now.
The last pandemic was in the 20s. Normally diseases and things like that, a venue wouldn't be responsible. The only type of case law is there is if somebody has something and they knowingly go and try to give it to other people. That's a little different, right? Where they're trying to do it. That's intentional. That's not negligent. So it just makes it real unique that you now have these guidelines and restrictions that create a duty to people that don't normally have those same duties.
As a vendor or a venue, then I could face some sort of backlash, penalty, punishment for violating these
Sure.
restrictions.
I think the venues are probably the ones that are most at risk. They're the ones that, there's specific health protocols that are put on that website. I think it's open.texas.gov now, is that they changed the address. But it talks about wedding venues specifically.
Yes.
So they have specific protocols. Well, I've seen a lot of DJs, photographers that, they don't have specific protocols that apply to them, but they're concerned about these things too. And I think those people don't have that much to worry about in the grand scheme of things. When you're handing somebody a microphone, do you need to have them sign a waiver before you give it to them? I think that's a little bit extreme. But venues have the responsibility to not only their employees, they're also required to make sure contractors are abiding by these rules. And unfortunately, it does not define contractor in these orders. So, there's two types of contractors. There's contractors I hire, or you could say that the vendors that are contractors that the bride and groom have hired that are performing their services at the place do these rules that the venue have to follow apply to them. And I think that's probably a safe assumption that the venue's just responsible for everybody on the back end, whether that be their staff or other vendors that are there.
Okay. Is there something I need to do, some protocol I need to follow, if someone on my staff tests positive for COVID sometime after my event?
So with those health protocols, it lists what to do in those type of circumstances. So if somebody tests positive, anybody that's had direct contact with them has to be quarantined for that quarantine period. So some of these venues that only have 2 or 3 people that operate them, if one person tests positive, they might have to quarantine the entire staff. Well, fortunately, it's just the people that need to be quarantined. The building doesn't need to be quarantined for that same period of time, so you can bring in other people that weren't exposed to then run those events and still keep things going.
Oh, okay. You said, when you're talking about these protocols, are you talking about the Open Texas checklist?
Yes, yeah.
Okay.
The checklists, and they're kind of deceptive. They're called checklists, but they're health protocols put out by the Department of Health and Safety. So even though they're checklists, they're a lot more than that.
You brought some examples of things to show today that you've actually seen. Demand letters, lawsuits even. Can we pull up some of those
Sure.
to talk through them? We were talking about this cancellation and demand letter just before we started this recording, and you were pointing out some very why this letter is so interesting.
So, obviously, as we're going through coronavirus and COVID and everything else that's going on, timing is going to be very important. Were restrictions in place when this wedding was supposed to happen? That makes a big difference than if there's no restrictions when a wedding's supposed to happen. So this demand, my client received, it was April 1st. So April 1st, you still had stay-at-home orders that were in effect everywhere. that were expiring at that time, I believe at the end of April. It was either, April 30th or shortly around there. So this is a letter my client received April 1st for a wedding that was scheduled for May 24th. So about 6 weeks later, you have this demand where they want to cancel the event. And if you scroll down a little bit, it just kind of talks about how coronavirus is a global pandemic and it's bad and people need to isolate, and all these things about just generally why coronavirus is bad. But in this letter it doesn't talk about, hey, we signed this contract, there's this clause that says this, there's this that's happened, here's a case site that talks about what we're trying to argue. Mm-hmm. It just generally talks about how this is bad, and this is in a demand letter that I would say isn't the greatest in trying to prove their point. I think this was just trying to scare my client into whatever these people wanted. My client was in Weatherford, and if you look at the mailing address for the attorney on it, he's in Amarillo. Yeah. So usually what that tells me is this was a family friend of somebody who was either the bride, the groom, or their parents. So that, usually you won't get attorneys from out of the area handling something that could be a lawsuit. I mean, you're just going to have to travel for hearings, and these aren't big money lawsuits where that even makes sense. So ultimately what they wanted was either to, and it's the last sentence of that paragraph there, they wanted to try to reschedule their event to specific dates. So it was July 11th, 18th, August 1st, or an evening in September. Well, this was in April, and my client usually books out at least a year in advance. So they didn't have those dates available. So in the alternative, they argued that if you can't give us these dates, we just want to cancel. So they were saying if they cancel, they get all their money back. Well, in my response, what I did is I told them, okay, well, what we'll do is we'll process your cancellation, which is effective April 1st, because that's when we got it. Mm-hmm. Your wedding isn't impacted by any restrictions that are currently out there. We don't know what'll be out there, but
because this was later in May.
Yeah, because it's later in May, so 6 weeks we have no idea what's going to happen. But you're wanting to cancel now, so because you're wanting to cancel now, we're going to process it today. We can still perform. We can still do all these things. They got a portion of their money back. I think at the time it was 25%. But if they didn't want to do that, what I had my client do is pull up their calendar and figure out other dates they had available, in the August time frame and around then, because a lot of people at that time wanted to move. And ultimately, that's what this bride and groom decided to do. They decided to reschedule. And interestingly, this bride and groom reached out to my client this week, and now they're trying to move it again. So,
really,
we kind of worked with them to move it. They weren't pleasant with my client when they were talking to them. When I talked to this attorney, he wasn't very pleasant, which is usually out of the norm for these things. Most of the attorneys I've talked to, we kind of work together because we know that this is something that's new. Everybody's trying to figure it out. Their clients want something. Our clients, they want something else. Mm-hmm. So most of the time we're able to work out something where, it's not exactly what everybody wants, but everybody's kind of happy at the end of it. Yeah. Well, this guy just didn't want to do any of that. So, if you could see the email they sent where it was, hat in hand, where they're like, hey, we're real sorry about, we want to move again. They didn't even talk about any of this stuff that they did before. They tried to just act like it never happened.
Gotcha. So if I get a letter like this for my venue, the things that I should look for, you say, to have a good argument, they need to cite
I would look
the violation.
Sure, I would look to see if it actually cites anything, whether it be a case, whether it be something in the contract. Generally you can tell pretty quick what's just a scare tactic. Like this is where it's just generally talking about stuff. It's not being very specific to what's going on here. Now, there's some demands that you need to really watch out for. For example, if somebody sends a deceptive trade practice demand, and I think it'll be pretty clear that that's in there. It'll talk about a statute. It'll talk about specific things you've done that may have violated that. Those kind of things start a clock. If there were going to sue for breach of contract, they'd have to send a demand that was compliant with the Civil Practice and Remedies Code, saying you have 30 days to pay, or we might try to get attorney's fees. It doesn't even have any of that in here. So, even though that they're trying to make a breach of contract argument, they're not talking about those things. But, ultimately, anytime a client gets a demand, they send it to me. I'll tell them, what I think of the arguments that are being made. And then the first question I ask him is, okay, well, how do you want me to handle this? Do you want me to just say, hey, we're going to stand by everything and, risk a lawsuit? Or do you want me to try to work it out? Because most of these deposits are maybe $4,000 or $5,000. And if we can just split it with the bride and groom and they pay them $2,000, they keep $2,000 and this issue's gone, that's probably a much more cost-effective business practice than racking up a bunch of legal fees to try to even go back and forth with demands. And ultimately, if I remember correctly, going back and forth with the demands for this took about 3.5 hours. And 3.5 hours at an attorney's billable rate can be over $1,000 just going back and forth. And, I try to take a, approach that if you want me to try to just do what I can as quick as I can to make this go away, that's what we need to focus on. And if we can get headaches out of the way sooner rather than later, that's the approach to take.
I think that's the approach that most of your clients would want to take,
Sure,
too,
yeah.
I assume.
And occasionally I get people that are just steadfast and no, we're not going to do anything. And they always make a statement that I always tell them, I don't think you understand what that means, is they say, I'd rather pay you than pay them. And as much as I appreciate that, I would rather they pay less money overall than pay me. Because it can quickly add up, and taking a lawsuit all the way, if something happens, can be $60,000, can be $70,000. I mean, it's a lot that goes into it, and once you're in a lawsuit, it's very tough to get out because you have to get them to sign off on it, you have to get everything, settlement agreements in place. It's just not as quick and easy as you get a demand, you negotiate something, and then you get a release right then.
And then it's done. Even just talking about lawsuits makes me nervous. I'm like, whew. So there are some people who would rather just risk paying those far more enormous legal fees just for the principle of
Sure.
being right?
Yeah, we always tell people when they say, I want to sue for the principle's always expensive. Unfortunately, it just is. You could be right, but if you go all the way, it might cost you way more than just working something out in the beginning. And I think that, a lot of these vendors and a lot of these venues, this is their first go round with any type of legal lawsuit or any type of legal demand even, and they're just not sure how to handle it. And I gave a lot of venues this advice in the beginning, is when they were actually force majeured, and they were most at risk being force majeured because most likely their contract said that they had to give the money back with a force majeure event. So I told them, get amendments, get them rescheduled. If you have one or two that don't want to reschedule, just give them a refund, and then you're done. Then you know that all the ones that you're at risk for are over, and the ones that were going to be problems are gone now. So you can focus on getting the venue booked, doing other things that generate money rather than something that's just going to ultimately cost you money.
Great advice. Great advice. That advice is going to be very useful for somebody listening to this. Is there anything else to point out in this document, or would you like to move on to?
Let's move on to the lawsuit example. This is one that a client they got. It was for a wedding that was in the force majeure period. So this particular client did not have a force majeure provision in their contract anyways.
Say that again, force what?
Force majeure. So a force majeure is an act of God provision. So usually it says if there's a fire, a flood, or something similar that stops somebody from performing, it details what the remedy is.
Gotcha.
So, you could have had your force majeure provision written in a way that covered coronavirus, pandemics, governmental restrictions. Typically it talks about act of God. And I watched a CLE for continuing legal education in the beginning that talked about this. And it's like, well, is a government restriction an act of God, or is that an act of man? Because if it's an act of man, then it's not covered under this provision. But ultimately, this client didn't have that provision, and why that provision is usually important, is if your venue burns down and somebody has to then go find a different venue, they might have to pay more, they might have to reschedule things, they might have extra costs. Well, the force majeure is designed to limit your liability and limit the amount that they could get under a breach situation. So even though it's beyond your control that the venue burned down, you're still breaching because you can't have the wedding that you're contracted to have. So you limit those consequential damages that were related to the breach. So in the epidemic and pandemic sense, nobody could really go anywhere and have a wedding somewhere else. So consequential damages, which would result from that breach, really aren't there. But if the force majeure was triggered, it might say that you have to refund the money if it applies. But since they didn't even have anything that talked about that, it's just a regular breach of contract. So this first page is the citation that you get when you're served with a lawsuit. It kind of gives you a little bit of information. This is in Justice of the Peace Court, so it's a little bit different than being in some of the other courts. The deadline to answer is a lot quicker. You only get a couple of weeks rather than 3 weeks.
Where is that deadline in here? Can I find it?
It talks about it right there in that first paragraph. It says your answer is due by the end of the 14th day after you were served with these papers. Okay. So if you get a lawsuit in county court at law, district court, you'll get something similar. The deadline there, it's about 3 weeks. It's 20 days. It's the Monday after the expiration of 20 days. So it's about 3 weeks. It's a little bit longer. JP Court, everything in JP Court is on a much shorter timeline. Things are really restricted. Most likely, if you're going to get sued for breach in these scenarios, they'll probably end up in JP Court. Okay. And why JP Court's a little bit strange is that the Justice of the Peace might not even be an attorney. So they don't have to have a law degree. So sometimes you get rulings and things coming from JP Court that really don't make a lot of sense. So they can kind of do what they want, and your remedy, if you get a judgment against you in JP Court, is you can appeal it to a higher court, and it just starts over, but you have to post bonds and things that get you there. But it's a little bit of a different animal being there rather than being in a district court or county court of law.
Okay. So this is, if I am being sued, this is what the lawsuit will look like. If I don't receive this document, I'm not being sued?
This page it's basically a cover page with the citation. If you go to the second page, where it's the start of the original petition, this is the actual lawsuit. This is what a lawsuit looks like. It'll say, so-and-so versus so-and-so in whatever the court's going to be. And it has different sections. You'll start with, usually it doesn't have a summary at the top, but you start with the parties, and you start with venue and jurisdiction, where it makes sure that the lawsuit's being brought in the right place. They're talking about the facts that make sure that where it's brought is appropriate. Then there'll be a statement of facts that kind of outline what's going on, kind of what happened. And these statement of facts are it's real simple. It's defendant operates a wedding venue. In June of last year, they contracted to have a wedding on April 24th of this year. April 24th, I think we were still, it was in those restrictions. There's actual restrictions in place. They didn't hold the wedding on April 24th. And then, the last paragraph, they're asking for their money back. So this client took the approach that they wanted to only reschedule people. So even if people asked for a refund and they had an event that they couldn't perform, they still wanted to just reschedule. And this bride just didn't want that. And unfortunately, this bride probably will be successful in her claim because of the specific facts that happened, where they couldn't perform, there were these restrictions, she asked for her money back, and they didn't give it to her ultimately. That's probably the best case scenario for a bride that brings a lawsuit. So after the statement of facts, if you scroll down, it's got the actual causes of action. So this one it's just breach of contract. If you go to the cause of action section, that's kind of what's going to tell you what you're being sued for. So this one is just breach of contract. It's pretty simple. They had contracted. That didn't happen. They want their money back. So this one isn't too complicated. Even though there is an attorney involved, it's really just a very basic lawsuit that they brought.
Can I move to this third document that you
Yes.
brought us? And this one, particularly interesting because you said, as we see on the date, you just got this yesterday.
Yeah, it was yesterday. So this is a client of mine. They get this is an email where the wedding is November 6th. And due to the current pandemic, is what they say, they're going to move the wedding from the DFW area and they want to move it to Georgia, which I guess is where they live right now. So under the contract, I have, this is a contract I wrote, so I know what it says. It's got a tiered level of damages if somebody breaches. So at the current point they're at, they can get 25% of the price that they've paid back. So they're asking for that to be paid back, which, all that's pretty just straightforward, pretty standard stuff. What's real interesting is their last sentence in there, or the second to last sentence, where it says, I reserve the right to have all my money refunded to me if there's another government shutdown. So you can't kind of have it both ways. You can't say, I'm going to cancel today, but if here in 6 months I could have had that wedding, I get my money back again. You can't really put the risk of that on the venue. So what my client did here is they emailed them back saying, look, we'll process your cancellation today. We'll send you that check. That's not a big deal, but we're not gonna, that's not gonna be how it works if we're shut down. That's just not what's gonna happen. And I think a lot of people are getting emails and phone calls that are very similar to this. Or they just want to cancel for a wedding in November. They just want to cancel. They don't want to have it because they're afraid of what's going to happen, and they think because there's these external factors that really kind of makes a difference. And I've used a phrase to some clients that just because there's a coronavirus does not excuse contractual performance. Just because it's out there, that really doesn't alter the terms of what's going on. Now, if you have government restrictions that alter the terms, that's different. But just having this out there, they kind of want to say, well, just because there's something that could happen, we want to cancel. Well, if you take that same approach with the venue burning down, just because the venue could burn down, we want to cancel. I mean, that just doesn't work.
Yeah. So what do you suggest then? Do you suggest we start with our contracts from today moving forward, we start adding other things in that would protect us, like specifically mentioning pandemics?
Yes, yeah. I mean, the biggest thing to take away from this is revise those contracts. If you don't have a force majeure provision, add one. And what I've done with force majeure is you have your traditional force majeure stuff, your fire, your flood, your acts of God. And then I break out epidemics and pandemics by themselves, and under those scenarios, they can only reschedule. So it defines, hey, if this happens or if this continues to happen, what their remedy is. That way there's no question. And if you don't have a cancellation provision, if you don't have those things, make sure that you're spelling those out too, just to bring everything up to where there's little to no confusion. And if you have these provisions that you can point to and say, hey, this is what it is, then that's a better place to be in. But I will caution everybody, what I see the biggest mistake that a lot of people do is they have a termination provision that says they get to keep 100% of the money, even if the event doesn't happen. Courts don't like that. If you can't perform the event, if they cancel a year in advance and you're saying they have to pay 100% as if you performed, that's usually not going to fly because you have so much opportunity to rebook and you have a duty to mitigate damages and other things that you just can't get away with that. Okay. So I always go with a tiered approach. As you get closer, the amount that you can keep gets more and more, which represents, the risk. If somebody cancels a year in advance, you have a good chance of rebooking. Well, if somebody cancels a week in advance, that chance isn't there.
Preston, that's really all of the questions that I have for you today. Is there anything else, any other bit of wisdom while I have you here that you can leave us with?
I just tell everybody that eventually this will end. Eventually it'll get back to normal. It sucks right now. There's no other way to describe it. It's not great. As things happen, just, be flexible, stay upbeat. I know it's hard to stay upbeat with everything going on, and And if you need legal advice, don't be afraid to seek out legal advice, because I can give people answers in 15 seconds about a question that they've been thinking about for days and worrying about that's not even an issue.
And Googling all over the
Googling
place trying to find.
and reading all kinds of stuff that probably don't apply.
Gotcha. So if someone does want to reach out to you with some questions, how can they get in contact with you?
So, email's probably the best way. My email is pward, W-A-R-D, at smithwardlaw.com. That's the easiest way to get in touch with me. I try to be real flexible and just, I've been answering a lot of people's questions, without even charging them. Like I'd much rather just answer some fellow vendor questions and give them that peace of mind than to try to, make a couple of bucks off of it.
And that's really kind of you, and that's how I found you, is because you were answering some questions of other vendors that we were kind of in the same group with. So that is much appreciated by many people. So thank you for that.
No problem.
And thank you for joining us today.
Well, thanks for having me.
And thanks everybody for watching. We appreciate it very much.